Hello, I'm Anna from law firm Cobalt. I see that a lot of people are thinking about food right now, so hope I'm going to be a bit fast and short in my presentation. The first question, kind of classical question for such type of events, is how many, are there any lawyers here? Quite a lot. Are there any technical guys here? Yeah, okay. So are there any decision makers here, just like board members? One person, at least one. Okay, fine. So data protection is classically connected, and GDPR is classically connected with fear. I think that you might have this feeling after the very first video, if you were present at the first from the beginning. Yes, so that the data protection, hacking going on, everyone should be afraid. Yes. A lot of people are afraid because of potential of getting a lot of sanctions, huge, big sanctions. I mean, 20 million is not so small amount of money, yes? And as a professional, you have to help your firm, help yourself, maybe if you're an individual practitioner, to cope somehow with the GDPR compliance in order to avoid this huge amount of penalty. Why are we usually afraid? We're usually afraid because we don't know how to control the issue. We don't know how to find a solution. Good news is that GDPR is not so something horrible. It also provides you, gives you some answers how to control the situation, which steps should you take in order to avoid these huge sanctions, and in order to control personal data, actually. And one of the questions that is very important today, the flow of personal data. The first and the very important thing is to control where personal data is today, because it is the first task you should have, and it is the hardest task you can experience while you are trying to comply with the GDPR, to control personal data that you have. And one of the aspects of controlling the flow of the personal data is actually controlling where geographically personal data is. Is it within the EU? Is it in your country? Is it in your office? Is it somewhere else? And GDPR actually, within the context of GDPR, it's very important to understand whether personal data is in the EU or whether it is outside of the EU. So, and there are a lot of, and there are some steps that I'm going to speak about in order to understand if personal data is outside the EU, and if it is, what steps should you take in order to comply with the GDPR? So, what I do, I'm a data protection officer. I have a cybersecurity license. I work at a Cobalt law office, and what we're doing, we're helping our client to comply with the GDPR at the moment. We have a lot of work, and I'm also afraid. Yeah, I have a very strong fear that 24 hours will not be enough within the next 6 months with these compliance issues. So the topic is related to, first, understand what personal data is, to understand if the personal data is outside of the EU, Europe, yes, and if it is, how to comply with the GDPR. So we'll go through all these three parts of the topic. Before that, you should understand who should care about this stuff. So I asked you in the beginning of my presentation, who are you? Lawyer, technical guy, decision maker. Classically, of course, board should take care of the operations of the company. However, if you're an employee or a consultant who is responsible for the compliance within the company, you should also take care, because, okay, the company will get sanctions. However, board may be responsible, well, depending on the state that you're situated in, board may be responsible for the problems and for the sanctions imposed to the company. However, if you are a specific company responsible for implementing the GDPR in the company, it might be that you also will have to pay some compensation to a company for your failures. And by the way, if you're just an ordinary employee who is not responsible for implementing GDPR, you can also be responsible, because actually a lot of employees just work with personal data every day of your life, and it is necessary to understand how to take care of this personal data. Who knows what personal data is? Maybe you have worked already with personal data in your everyday activity, you attended some presentations. So generally speaking, personal data is any information that is related to identified or identifiable natural person. So generally, this is any piece of information that can lead to a specific person. It can be actually, there are different examples, yes. You can take it means that you can take this piece of information and understand that this piece of information is related to one specific natural person. So how do you think, is all of the information that is presented here is personal data? Or is there any information that is not personal data? Yes, actually it really depends on the context. Sometimes some of the information presented here is cannot be personal data. But sometimes, actually, any piece of this information, any example of this information can be personal data. So first thing that you should think about, if you're dealing with personal data in your case, okay? Because if you will think about any information that you have in its flow outside the EU, they can be, you will just do too much work that you don't need to do. You need to think only about personal data within GDPR. So the next question that you should answer is whether the personal data located outside of Europe, so basically outside of the EU, as the GDPR states. Another aspect is that if, and the question, is the GDPR related only to transfer or transit of personal data? So this may be a tricky question, because a lot of some of the companies function like that they don't really store information for a long time at a certain place. The data, for some certain reason, just passes the geographically, yes, one state. This is a transit. This is a huge question, actually, whether the personal, what is the amount of time that personal data should spend geographically in one place in order to be stored there, and not merely to experience a transit through the state. GDPR doesn't give any answer to this question. However, you should evaluate in each specific case whether a specific state will have a control over this personal data. And why actually all this stuff about personal data and its geographical position is so important, and jurisdiction is so important. Because once the personal data is situated in some third state that you cannot control, for instance, just like India mentioned, or China, yes, China mentioned here, or India mentioned here, EU doesn't think of these states as data protection like of the states that are safe for personal data. It means that you cannot control the government, you cannot communicate with the government. Government maybe the state have different laws that are not very safe for the personal data of you, of your clients maybe. And once something happens, you will not be able to do anything with the personal data when it is situated in this country. So that is the reason why this stuff is important. You will have no control over the personal data. Yeah. So in order to evaluate if we are speaking about transfer or transit, you should really think of the fact whether, if something happens, you'll have the control over the personal data. If you don't, then this is a transfer. A technical question, maybe. What does it mean to be outside of Europe, outside of the EU? What does it mean? If we're speaking about physical personal data that is stored somehow physically, just like paper documents, it's quite easy, yes? It means that this data is physically in this place. Basically, when it crosses the border of a certain state, it is located there. However, if we are speaking about digital information, since there are tech guys here, can I ask a question whether a single bit of information can be personal data? Okay, so which amount of bits can be personal data? So when these bits cross the border of the state and goes, I don't know, to Russia, at which time should we consider that personal data is in Russia? Actually, yes. And with digital data, it's very important to understand that data should be located and stored in the state. Because, for instance, one of the questions is whether if you can access the information on your screen. For instance, homepage that has a certain list of personal data presented here. Does it mean that if you can see this information from your phone, access homepage from India, does it mean that this information is now located in India? Actually, generally no. However, it depends on the place where the server is located at. Yes. And you should check it, yes, with your domain services provider or hosting services provider, where actually this homepage is located, is stored. If you can tell about that. Speaking about cloud services and emails, yes, if you can only see this information on your screen, doesn't mean that this information is now in this state. Yes, sometimes it seems like very safe because you can go, I don't know, to business trip to India and see the information that is really stored in Latvia on your screen, it will be okay. However, when you're in Latvia, you also can see the information stored on your screen that is really stored in India, and you should you should be cautious about that because it's also actually can be an international transfer of personal data if you transfer information from your firm to the server that is located outside of the EU. Okay, so this is another piece of information. This is another important point that should be taken into consideration, where both physical and digital data stored at. Yeah, yeah.
When you go on location with your mobile phone, where your email stored?
Yeah.
You take along with your phone.
Yeah.
Emails is here cached as well. So is it transfer? Is it?
Well, it depends. It depends. If you can only access your email and read email on your screens, it doesn't mean that data is stored in the place where you are at. However, if you save any information from your, if the information is stored in your phone, for instance, yes, then it is stored in the state because the information is not stored in other places. It's in your phone. Yes.
It's some cached information, some copies, some small amount of the information.
Yeah. So if this information is personal data, yes, then we are speaking about GDPR. So it is important where personal data is physically located. Another interesting question is that, for the reason that I have already mentioned, yes, that actually, if information is geographically situated in one state, it means that theoretically this state has the control over this information because of the jurisdiction. Yes. So another question is that if you have password, if you submit your password and login, for instance, for state authorities of this third state, in case of any emergency situation or violations or I don't know, examination by police, if you have to submit the information, your login and password, and they can access your information. Yes, so whether this simple giving out, submitting your login and password means transferring personal data. Yes, because this person, policeman, for instance, or can do anything with the information that is stored in your device, for instance, or that is accessible through your device. Okay, so first thing is to understand that we are really dealing with personal data. Okay, the second issue is to think about is where data located at whether it is in the EU or outside of the EU. Yeah, so it's not so easy as it might seem from the first view. And the third thing is what can we do in order to comply with the GDPR. Of course, we should think about this general data protection guarantees and general principles that should be taken into consideration within the GDPR. However, if we transfer the data outside of the EU, we should also think about some additional guarantees, as the GDPR states. So the first step is to understand, okay, we know that the data is outside of the EU. The first step is to see whether this third state is included in the list of safe states that is adopted by the European Commission. Yes, so there are different states included in this list, just like Argentina, Israel, Canada, and other different states. Yes. However, if this state is not on the list, you can proceed to the next step and think about different guarantees there is available to you. You can't, depending on the situation, you cannot pick any of them. Yes. So, for instance, first option works for a group of undertakings. So basically, these are for a group of companies, holding of companies, etc. So you have a group of companies, and these companies are situated all over the world, including the third states. There is a very convenient option in order to, basically, this is a multilateral agreement between all these companies or companies that are involved in personal data transfer between the states to adopt binding corporate rules, basically multilateral agreement between all of the entities. Another option is standard data protection clauses, yes. However, basically, this is a very similar. These are very similar things. Just binding corporate rules is a multilateral agreement. Standard data protection clauses can be concluded between two parties. Okay, so but however, they are quite similar. So, what you should include in binding corporate rules and clauses. Standard data protection clauses are available at the homepage of the European Commission. There is a list of information, actually a ready-to-use draft of the agreement that can be used. But in corporate rules, there is no standard form. However, there are a list of requirements that you should think about. Basically, you should agree upon a lot of different things. About which kind of data you're going to exchange to transfer, principles that you're going and how you're going to work with the principles, just like which kind of purpose of processing, basis of processing, and other things. And another very important thing that you should mention is security. Yeah, so it's not basically only legal work, it's also a technical work and a technical thing to think about. It doesn't mean that you should really include just a small clause about companies should care about security. It won't work. You should really agree upon security measures and technical measures related to personal data processing. If you are two partners that are involved in personal data exchange, you can also enter in standard data protection clauses. What is important here is that all these agreements really can help you in order to cope with such personal data transfer that takes place on a regular basis. Yes, so it means basically that it is a part of your activity. Just like you transfer personal data of your employees, for instance, to another company for business trips purposes or for educational purposes, or in order to manage human resources department work, etc., or in order to provide some data storage services to your client. So this is regular personal data transfer. If there is an association and you're a member of associations related to some kind of profession, for instance, HRs or cloud computing or something like that, you can conclude and adopt code of conduct. Basically, a very similar thing to binding corporate rules, but related not a single holding of companies, but rather an association of companies, of specialists related to one sphere, yes, as I mentioned. And this code of conduct can be adopted, but however, it should be, this version of this code of conduct should be confirmed by the local authority, yes, just like data protection authority. You cannot adopt it and just like use it. Certification mechanism is a bit more complicated issue. It can deal not only with personal data transfer outside of the EU, controllers and processors, these companies involved in personal data transfer, can get certified for this certain type of activities with their local data protection authority. Yes, and basically, you will have to prove, your company will have to prove that you really need to transfer personal data outside of the EU, and that they are going to do this in accordance with the GDPR. If none of the steps, none of the options is available, or you cannot really enter any agreement because not all the partners, not all the cooperation partners are very happy to conclude any additional agreements, you can proceed with other options. However, you should be very cautious here because of the fact that all of these options are usable mainly for non-regular personal data transfer. So for instance, you need to transfer personal data of your client or of your employee just for one business trip or for several business trips, and that's all, yes. It's not something that is happening on a regular basis. If it's happening on the regular basis and you cannot provide the previous, and you cannot go on with the previous options, it means that you need to, for instance, to receive the consent of the data subject, for instance, your employee or your client, for each personal data transfer that happens, which is quite, which is not very comfortable for many companies. So consent of the data subject is the first option. Contract can be a basis. So for instance, if you have concluded a contract with the client in accordance to which you're obliged to provide any type of services that cannot be provided without transferring data to another state, then this can be used as a basis. However, this contract should be really very precise. Public interest, yes. However, this is a matter of public interest, and the list of bases that can be seen there accepted, just like public interest, are mentioned in local legislation. For instance, you can find them also in the GDPR and in the local Latvian draft data processing law. Legal claim, so it is mainly related to the facts when there is a legal process happening between two parties. Yeah, so the client or the employee sued the company, and the company really needs information about a certain client in order to protect its own interests. Vital interest, yeah, so it's mainly related to the fact when a specific data subject, a natural person, needs medical assistance, and this person cannot give his or her consent. Yes, so in this case, in order to save the life of this person, the personal data can be transferred outside of the EU. If the information is stored in local register, in a public register, for instance, company register, and this information is, for instance, about board members, sometimes other companies' representatives is available and is supposed to be publicly available not only for the residents of this specific state but internationally. Then this information can be transferred internationally. So if any of these guarantees can be used and you use any of these guarantees, then actually you can proceed with the transfer of personal data. So these are mainly three main steps. First, personal data. Second, outside of the EU. And third, these guarantees and measures that you should take. Why is this important? First, expenses. And expenses, by expenses, I mean not only documents and processes, but also sanctions. Yes, you should think about which guarantees, which processes would be more convenient to you, and another thing is reputation. So what can you do in order to ensure compliance and to understand whether you're compliant with the GDPR requirements? Yes, you can do this completely internally. You should check all of the documents, procedures, personal data available and personal data transferred outside of the EU, because not all of the companies really understand that the data is being transferred outside of the EU. Just don't know what, for instance, what this phrase outside of the EU means, and then proceed with the implementation. Yes. To introduce documents, additional guarantees, to introduce personal data register in order to know and to understand what kind of personal data you're processing, and proceed with maintenance. Why this is important? Because there are some new requirements introduced by the law all the time, and I think they will be introduced within the nearest time. Communicate with the data subjects, with the clients, because each company, each controller has an obligation to inform all of these clients, natural persons, about this international transfer of personal data by its own initiative. At the very beginning of the personal data processing, each data subject should be informed whether his or her data is being transferred outside of the EU, and which guarantees the company is going to use in order to transfer this information. And data subject has the right to request this information from any company. So basically, this is how this compliance can be ensured. And this is all today. Yes, I hope that you will be able to comply with the GDPR, to act, and to help your company or yourself. Okay.
I got a small question. If personal data is stored in some cloud solution like Dropbox or Google Documents, and it's actually transferring all over the world between their servers, is it called as international data transfer, or it's stored locally somewhere?
Okay. First, if we're trying to trace the data, first, for instance, the data is located. This is some kind of client document, the scan of a passport, for instance, and you upload this to Google Documents or something like that. Actually, you should control, because Google have servers all over the world. Yes, the data can be stored anyway. Some of the solutions and service providers let you choose whether your data can be stored only within the EU. So this is the new option that is available. But however, if you upload your data from Latvia and basically this data ends up somewhere in Chile, where, for instance, Google has its servers, then it's an international transfer.
I have a question. A centralized logging system in USA logs website access logs, basically IP address and, for instance, username. My question is that also a problem, as in we need to make sure that the logging system is GDPR compliant, or is that exempt because we would use it for security monitoring purposes?
Well, first thing, in order to understand whether GDPR is applicable, at all, yes, you should think about this first clauses of GDPR related to its applicability, yes. So if you are speaking, for instance, about any commercial activity, okay, GDPR is applicable. Another thing that we should understand whether we're speaking about personal data. IP address can be personal data because it can be associated with a specific person, yes. So if this data is processed by any entity or authority situated in the United States, for instance, it means that it processes personal data of, for instance, EU resident for some purpose. There are a lot of actually, GDPR is now applicable also not only to EU companies, but the companies all over the world, so it can be applicable to that company. And you should look whether there is a certain basis, yes, to process personal data in this case. This can be a public interest, for instance, yes, because there should be some reason under this personal data processing.
It was for security logs.
Mm-hmm.
Like if an incident happens, then the company can actually identify possible attackers from the IP and usernames associated with the incident.
Okay, so in this case, the basis, yes, would be the protection of the interest, yes, of the company in the case of the incident, yes. However, there is actually can be a very good question within the context whether we have international data transfer in this case, yes, because person tries to access the resources of the I don't know U.S. company, and the person as a data subject transfers its data by its own initiative. Yes. So, for instance, U.S. company doesn't transfer the data anywhere from anywhere other part of the world. Yes, but this action can be GDPR compliant because this is a protection of the interests of the company, and this is a completely legal basis under the GDPR.
Okay. So, vice versa, if a company here in the European Union has a web service or website with a customer database, and those customers are actually not from the European Union, China or United States, then does GDPR applies to those guys' data? Or
yes, actually GDPR applies. There are two factors for the application of the GDPR. First is that controller company situated in the EU. It means that it should process any personal data in accordance with the GDPR. It doesn't mean there is no ties related to citizenship or residency of these data subjects. And another thing is that even this company is located outside of the EU, but it processes the personal data of EU residents for the purposes of providing goods and services, then GDPR is also applicable.
Yes.
Yeah.
For example, company have HQ in one country, not EU country, but in EU, this company has subsidiary. And in case of data and the databases, this company can have databases as in, for example, US in HQ. Also, database is in EU. But in terms of the security and the data disaster recovery, this kind of cases, this data can migrate between the data center. In this case, should be compliant with GDPR.
Yeah, if this data is personal data, yes, and this migration takes place on a regular basis, it's better to conclude binding corporate rules, yes, this agreement between headquarters company and I don't know, European subsidiary, yes, related specifically to these kind of situations, yes, if this migration happens only within such type of situations. If this is some kind of incident and it doesn't plan to carry out such a kind of personal data transfer on a regular basis, just like, I don't know, 3 times or something like that, maybe it is more useful to think about all these other guarantees, yes, just like consent or something like that, if it is possible. However, if these are related companies, yes, this is holding headquarters and subsidiary, maybe it will be easier to conclude an agreement that can be used by both companies, and they will know how to proceed if in the case of any incident. Yes, binding corporate rules. Yes, it's. Yeah. Can you see the first group of undertakings and the binding corporate rules? There is no specific ready-to-use form accessible at the European Commission homepage. However, they have a lot of detailed instructions on how can you drop the document and what should you include in this document.